Good evening, this is John Milburn. We're up to week 4. Tonight we'll be talking about international environmental law and also the federal aspect, the Commonwealth government's aspect in environmental law and planning and environment decision making and legislation. But before we do, I just want to deal with some practical issues. By now, I suspect you're becoming a little overwhelmed with the amount of reading. It's a lot of reading, it's a lot of material. I understand that and I get that. If anyone is really becoming overwhelmed and you want some more practical advice, please ask a question through UCrew and I'll provide some further detail. But it is important when studying law, even if you're not a lawyer or even if you're not studying for a law degree, that you have some basic skills. Now, we've talked about some of them, but I'm going to be in a bit more detail tonight. So adopt a systematic approach. And the starting point is, know where to look. So tonight we're talking about federal, so that would be the EPBCA, or the Environment Protection and Biodiversity Conservation Act. That's generally the starting point when you're talking federal. State level in Queensland, the Sustainable Planning Act, of course, about to become the Planning Act, as I think Madonna identified in our UCrew discussion. So, but for the moment, it's the Sustainable Planning Act. So if you know the key pieces of legislation, that's a great start, because I do want you to start by looking at the primary sources, which is legislation and case law, and then have a look at the secondary sources, Bates and other commentaries, rather than the other way around, which is perhaps the way you're used to studying, looking at the secondary sources first. So have a look at the primary sources first, but if you want some good quality information, some of the paid services, LexisNexis, Thomson Reuters, CCH, and the free services are also very good. Ostley, Jade Barnett, we'll have a look at those a bit more detail tonight as well. But you need to become familiar with those and you need to know your way around them to a degree. Then you're thinking, well, there's already so much material in textbook, and now you're referring me to the internet sources of material. How do I possibly get through it? Well, one thing you need to do when studying law is read actively and very efficiently. And there's a difference between speed reading, which is scanning, and perusal, which is a detailed reading. And it depends on the circumstance and depends on where you are with your legal research. So let's have a look at the big picture first. You need to identify the task at hand, and sometimes that is a little obvious. This is clearly a planning and environment issue. But sometimes it's not quite so easy to determine, and it may be that you need to consider things like constitutional law, which we'll touch on tonight, or contract law, torts law, criminal law. It's not necessarily going to be cut and dried. So what I like to think about is a process of brainstorming. The brainstorming is where you're really thinking of all the possible different options at a big picture level before you start to get right into the detail. So just spend a moment on that, and you might discount things. You might say, not relevant, not relevant, not relevant. But then you might think, hang on, alternative dispute resolution could be applied in these circumstances. And we'll talk more about ADR later in the course. But think about those different options, and it's not just a matter of litigation, go to the Planning and Environment Court, that's the only solution. Through brainstorming, you may come up with other options. In the course of your legal research and the advice that you give, you need to think about the time frame, and in applied situations for lawyers, we need to think about the cost and the consequences of what we do. It's no good to anyone if you spend all night researching a very fine piece of law and go off on a tangent. You need to get your sleep, you need to exercise, you need to keep it in balance. So think about what you need to achieve and the time frames, and then to some degree work backwards. And I use that statement a lot, so that you're thinking about the big picture, where you want to go, and then you come back and work within those constraints. Trust me, lawyers who have practiced for 40 years don't know all the law, haven't even got a chance of knowing all the law. I mean, I guess it's fair to say that I have either practiced or studied or considered law pretty much every day of my life since I've been 17, and I know just a very small fraction of the law. But what you need to do is have an idea of the bigger picture and where to start looking. So don't be overwhelmed is what I'm really trying to say. There's a lot there, but there are techniques that you can use. Now, if you do come across an area that you think this is really important, it might be, for example, something to do with ecological sustainable development, then, and you find the piece in the legislation that deals with ecological sustainable development, that's when you want to slow right down and look for special words. And some of the words that lawyers look for are words like unless. You know, it can make a big difference. It can turn around the whole context of what you're doing. So when you get to that detailed reading, you may have to read and reread and look out for those special words. For those of you that are not coming from a law background, you're no doubt used to Harvard-style referencing, where you reference in the body of the material. Just bear in mind that I'm teaching this as a law subject, and in the law subject, we use the Australian Guide to Legal Citation. In essence, have a look at your textbook, and you'll see that Bates uses footnote referencing, and he applies the AGLC in his writing. Have a look at cases. It's all pretty much AGLC referencing. In short, use footnotes. Don't put it in the body of the text, and you won't see references to URLs. If you're referring to a case or legislation, then refer to its citation in the formal legal sense, but not the URL, the internet link. That's not the way we generally write in law. Okay, now a couple of sites that I want to highlight tonight. I need to share the screen. As I'm doing that, if you have any questions, comments, if I'm scaring you unduly, please let me know, but I'm sure you're coping well. So on my screen, you should see Jade Barnett. I love this site. I'm sure many of you have already subscribed. You can sign up there, and I've circled it, the yellow icon. Click on that, sign up. You'll get emailed cases straight to your inbox every day. It's terrific. Now, you'll see up here I've typed in environment in the search index. If we click search now, you'll see that it'll come up with a range of cases, primarily that relate to environment. Let's have a look at the first one, Green Tree against the Minister for the Environment and Heritage. And you'll see that it's got some highlighted areas because I wanted environment, so it's conveniently highlighted the word environment for me throughout that course. Now, up here in the top right-hand corner, you'll see a great feature called Jade Case Trace, and that gives you some really interesting information, like the litigation history here. And it will refer you to cases that have cited this particular decision or cases cited by this decision, and likewise for legislation, etc. So a wealth of information there, but again, the caution is don't get too bogged down, don't be daunted by this, but treat it as something where you have some inside knowledge now, where to look for information and know your way around an excellent and free public website. So Jade is just terrific. So if we go back to Jade, you can sign up for free, and I'd recommend that you do that. And when you register, you'll get alerts and materials sent to your inbox. All right, the other one is, I love free service, is Ostly. Here's Ostly. If you haven't looked at this, spend some time having a look. You'll see cases and legislation, Commonwealth, Queensland, etc. Let's go into, say, Queensland, and you'll see here Queensland legislation, consolidated acts. And if we choose the Sustainable Planning Act, down the bottom here, it gets straight to the legislation. Boy, if I had this in, I started in practice in 1984. If I had this service, it would have been absolutely terrific, because what I had to do was buy the legislation, and then when an amendment came out, I'd buy the Amendment Act, and literally we would cut it and then paste it over the top of the old section that was repealed. So this is just a fabulous resource for everyone to share. Now, I want to show you something really good. I'm not sure I've shown you this already, but meaning of ecological sustainability is Section 8 of the Sustainable Planning Act. And there it is. That's what ecological sustainability is all about. That's the meaning. This is the feature I want to show you. Note up. This is great because what it does is give you access to information about that particular section, and not just cases, but also articles and maybe other pieces of legislation. So you'll see here that we have identified Lockyer Valley Regional Council, a case of the Planning and Environment Court decided on the 16th of April 2015. So it's really quite recent, and you just click on that link and you're straight into the case, and there's the decision of His Honour Judge Searles in relation to stay proceedings. The other thing is you'll find there's articles, and have a look at this. This is from the, if you like, it's not the Chief Judge, but he's the Principal Judge in relation to P&E Court, which is His Honour Judge Rackerman. And here is an article about the operation of criminal jurisdiction in the field of environmental law. And we will talk about criminal jurisdiction in environmental law and planning and environmental law later in the course. So there's an article by His Honour that I would actually recommend you consider reading, because His Honour writes in a very clear style. It's not an overly long material, but have a look through that, and it'll give you an idea of the criminal jurisdiction. So all of that we found by going to Ostley, going to the section, and then clicking Note Up is the facility there. So it's a great source of material. Okay, I'll stop the share and we'll start talking about international conventions and treaties. So, of course, in environmental law and planning and environment law, but particularly the environment aspect, it all flows down from the international treaties through to the Commonwealth and then through to the states, etc. And the starting point convention on the biological diversity, the Rio Convention from 1992. Now, there was the Rio +20 convention 20 years later in 2012, but they are conventions about biological diversity. So if you were going to have a starting point in terms of environmental law at an international level, I'd recommend you have a look at the Rio Convention from 92 and then follow up with the convention in 2012. Now, interestingly, almost every day as you pick up the paper or listen to the news, there's something that triggers your attention in relation to environmental law. And only tonight there was some talk about discussions about the Convention on the Law of the Sea, and that's another one that you might want to consider from an international level. So most of this is in your textbook, and you can have a look at it. I'm really just trying to identify, if you're going to look at anything, that might be the place to look. Now, how does the federal government incorporate international obligations into its law? Well, the first thing is that by merely ratifying or agreeing to an international convention, that does not of itself mean that it is created as part of our domestic law. It needs to be incorporated through domestic legislation. And of course, that means at the Commonwealth level and at the state level. But in terms of Commonwealth, we talked previously about the fact that the federal government just doesn't have an environmental law power. It came about after in COAG, which is very topical as well, back in about 92, same time as the Rio Convention, when the states effectively ceded control in relation to the big picture of environmental law to the states. And that followed the decision in Murphy-Oars in the Commonwealth and the Tasmanian Dam decision. So if you want to have a look at two cases, or pay particular emphasis to two cases that deal with the issue of the way in which the Commonwealth effectively grabbed power, perhaps that's a wrong term, obtained power, they are great examples of what led to the COAG agreement and the bilateral agreements from the early 90s. So have a look at those two cases, Murphy-Oars from 76 and the Tasmanian case, Dams case from 83. So after all of these High Court challenges, the Intergovernmental Agreement on Environment was created through COAG in 92, and I think that was in Brisbane. Now, the Commonwealth, of course, has no direct power, but in your reading, have a look at Section 51, and you'll see that Section 51(1) deals with trade and commerce power. That's the power that the Commonwealth used in the Murphy-Oars case. 51(24), now these are all in Roman numerals, of course, so it's good practice for your Roman numerals. 5124 is the external affairs power, and that was the one used in the Tasmanian Dam case. So have a look at section 51 of the Constitution, just get a feel for where the Commonwealth actually has constitutional power and get an idea of how it creates environmental law by dovetailing onto its existing powers, something that has an environmental flavour to it. Okay, and I hope I'm not going too quickly, but thank you for bearing with me. Now, really importantly in section 51 is section 51(31), so it's XXXI, you know, for if you're not up with your Roman numerals just at the moment. And that is, of course, the power of the Commonwealth to acquire property on just terms. Always think of the castle when I hear that phrase. And that's the section that was the key section, constitutional section, in the legal arguments in the movie The Castle. And you'll see that it has an environmental flavour, a planning and environment flavour in cases like Commonwealth against WMC, which is a 1998 High Court decision. That's 1998 HCA 8, and that was a dispute about compensation for loss of a transferable statutory permit to explore for petroleum. Now, the reason I'm saying this is that when we talked about this issue last time, we were talking in the context of licensing. Now it's a little bit different in that we're talking about permits to explore for petroleum, as was the case in the WMC decision. Now, in mutual pools against the Commonwealth, which is 94, there was a mere sterilisation, and in that instance the High Court said there is no compensation for a mere sterilisation. The Commonwealth must acquire some identifiable benefit or advantage in order for this to be compensable. So in Commonwealth against WMC, which is 98, there was a dispute. The company sought compensation for the loss of a transferable statutory permit to explore for petroleum. There was a detriment suffered by the company. In mutual pools, there was a sterilisation, but the difference between the cases seems to be that in WMC, there were statutory rights which were transferable to another party, which is worth money. And that seems to be a difference. If they merely extinguish a right, there's no entitlement to compensation. And another difference is, as I mentioned before, there must be an identifiable benefit or advantage to the government. So in Tasmanian Dam case, the Commonwealth did not gain anything as a result of, well, sorry, I'll just leave it, I'll gloss over that because I'm getting a bit too technical. But can I just say that another case that you might consider in this context is Newcrest Mining against the Commonwealth. It's 1997, and in that case, the court held that an effective termination of a right to mine was an acquisition of property, and what was acquired in that case by the Commonwealth was additional national parkland. So the court said you must compensate for that termination of a right to mine. It's a tricky area, but if we're looking in terms of international obligations and obligations of the Commonwealth, then section 51(31), dealing with the on just terms acquisitions, is important. You can read about this in your text, but if you're going to concentrate on cases, have a look at Commonwealth against WMC, have a look at mutual pools against the Commonwealth. That is 1994 CLR 155, and also think about Newcrest Mining against the Commonwealth, which is 1997 147 ALR 40. Okay, I know I'm moving fast. Are we with me? All right, just go to gallery view. Yes, we're hanging in there. Thank you. All right. The other case which is important is Spencer's case. I mentioned this last week. Spencer against the Commonwealth, 2008, FCA. The plaintiff was prohibited from clearing land without consent. And he said, well, look, that's depriving me of an ability to use my land reasonably. And bearing in mind, by this stage, he knew that he would have to argue the Commonwealth had acquired something. He inventively argued that the Commonwealth had gained a benefit because now it was able to meet its international obligations to reduce greenhouse emissions under the Kyoto Protocol. I thought that's a great argument. That's very inventive. In that instance, however, the court said that this is not characterised as an acquisition of property case. So you might have a think about that case as well. And the final case on that area, ICM Agriculture against the Commonwealth, 2009 HCA, that's ICM Agriculture, 2009 HCA 51. And the High Court actually went further and confirmed that in order to constitute an acquisition, either the Commonwealth or another party must obtain an entitlement to possession or control of property. If you know or have some understanding of those 5 or 6 cases and the legislation, then you'll be able to answer any question in relation to that topic that may come up, at least for my purposes. Okay, so let's get on to the EPBCA, the Environment Protection and Biodiversity Conservation Act. That's the key piece of legislation at a national level. And what we have here is some issues that deal with national environmental significance, and there are certain things that are covered in both the state and the federal pieces of legislation. And you'll see this when you go through the material. You'll see that both have requirements to trigger certain processes in relation to developments or projects. And what the governments have done is enter into bilateral agreements, which means that applicants are not required to duplicate process unnecessarily, where both Commonwealth and state laws apply. And you'll see that in action when we start talking about environmental impact assessment, which I think is maybe week 7. So just bear in mind that when you look at the EPBCA and the Sustainable Planning Act, you'll say, hey, these processes look similar. It doesn't mean the applicant or the proposer or the proponent has to necessarily comply with both. The state and the Commonwealth have bilateral agreements where there is a streamlining of the process. And in essence, in practical terms, what happens is the Commonwealth delegates it allows the state process to cater for both state and federal process, is what usually happens under the bilateral agreement. So keep an eye out for that. Now tonight we're talking about international law and federal law. Have a look at section 3A of the EPBCA, and it deals with the principles of ecologically sustainable development. So I mentioned that tonight specifically in the context of the Sustainable Planning Act. I'm now mentioning that same phrase in the context of the EPBCA, and the common thread between that is they both come from the 1992 Rio Convention, and it has, that phrase has filtered down from the international through to the national through to the state, and you're seeing the same practicality coming through. As a demonstration of how those international principles are reflected in practice, have a look at the video that I was involved in with Roger Carrick. Roger was speaking to me and some students in relation to his involvement in challenging the Paradise Dam case. Really interesting. People that, you know, are environmental activists do an amazing job. You know, I suppose developers and proponents might say they do an amazing job in the negative, whereas others may say they do an amazing job in the positive. But it's extraordinary that people devote so much of their time and expertise and talents to dealing with environmental law issues, and you've got to admire their passion. And if you look at that one that I did with Roger Curry, you'll really see that he is not only highly knowledgeable, but also highly passionate and very brave to take on a huge case, which he did. Okay, again, I know I've been moving pretty fast tonight. My intention is to try and keep these sessions to less than half an hour. It means that I move quickly. So part of it is really just saying, look, here are the main points. If you know this, then we can move on. Thank you very much for providing some responses to the weekly problems. I've added some responses, the different problems for the subjects, but essentially the problems for last week relating to common law issues. And I'll just do a quick recap. In terms of common law, which we talked about last week, common law does not recognise environmental degradation as actionable per se. What I mean by that is that common law will recognise things like negligence and nuisance, but not that someone is degrading the environment. That's not a common law action. But environmental law, admittedly, it's a creature of statute and law and policy, but it does that within the context of property rights and ownership. Now, that's the backbone of our, if you like, our capitalist democracy, and common law protects the rights of property owners. So you can't read the legislation in isolation with the common law principles, and of course, the common law applies unless it is taken away from the statute, by statute. So if you have a statute, it will override the common law, but if the statute doesn't touch the common law, then the common law is still good law. And the common law I'm talking about are all those principles that were developed over many years by judges. And in this context, I'm talking primarily negligence and nuisance. The other thing is that common law provides opportunity to provide remedies that would not otherwise be available. So remedies such as damages, or equitable remedies such as declarations or injunctions, or specific performance are all common law remedies. And finally, costs is a common law principle. And by costs, I mean the costs associated with winning or losing a court case. And we're not talking small amounts here. We're talking potentially hundreds of thousands of dollars in costs, so it's a big deal, and that's a common law principle. We'll talk more about costs in about week 11, maybe 10, and how that has a bearing on decision-making in environmental law. Okay, well, that's all that I want to talk about tonight. Unless there are any questions or comments, here's your opportunity. Otherwise, we will call it an evening. I'll stop the recording now. Thank you.